Hey friends, welcome to Stocks and Crypto Plays. I'm talking about AMC stock. We've got a lot going on right now, today, Monday. A lot of news you gotta watch. Hit like right now, hit subscribe, add notifications. Okay, before you forget, it's just a reminder. Okay, so we saw Adam Aaron put out the letter, right? Sunday night. Crashed AMC stock Monday, today. He crashed it. It was his goal. He wanted to crash it, and he did, right? We hit a low of 502 today, and we sprung back up to 560 right now, as of right now. And it's, not even noon yet. So we're going to see what happens. The volume is insane. We have an average volume of 20 million, and we're at like 140 million right now before noon. High volume is what leads to short squeezes, okay? So we're going to see what happens. Yes, it's discouraging. We're down, but you can thank Adam Aaron for that. That was his goal on Sunday night with that awful letter. Watch my video after this about the letter, okay? And you'll see exactly what I'm talking about. So, guys, the breaking news today. Thank you to Mr. Brian Tuttle, looking out for our team, looking out for us. He emailed this letter to me. So, this Izzo guy, Rose Izzo, Miss Izzo. Oh, wow, it's a lady. Congratulations to her. I was thinking it was a guy. Amazing. Miss Rose Izzo. Here we go. All right. She saw that Adam Aaron put out FUD yesterday, fear, uncertainty, and doubt. And I guess she knew he was trying to crash the stock, and she wants to take over a lead plaintiff role. That would be very good for our team because Allegheny, I think they're a plant. I think they're working with Adam Aaron, actually. Okay, but here we go. It says Rose Izzo's motion for clarification of the scheduling order, or alternatively for maintaining of status quo order pending appeal. Objector Rose Izzo, through counsel, moves for clarification of the scheduling order, alternate for maintenance of the status quo order pending an appeal of final judgment. Background. In contrast to defendants' predictions of financial ruin following rejection of the non-defunct old settlement, the opinion caused AMC common stock to surge above $7 per share and after-hour trading. Actually, it went above $8, Rose. But obviously, you are very talented to get this out, and your lawyer is talented, and also thank you, Mr. Brian Tuttle. So it says, and ape units tumbled. Good news. Even Adam Aaron concedes that there is no imminent crisis. His tweet in response to the opinion admits that if the company is unable to raise equity capital, the risk materially increases of AMC conceivably running out of cash in 24 or 25. In a few weeks, AMC will release its second quarter earning results, which will shed more light on the company's financial status. The breakneck pace of litigation is no longer necessary, if it ever was. As the opinion recognizes, Ms. Izzo seeks to become lead plaintiff so that the class will, going forward, be represented by one of the retail investors that helped save AMC and put its bankruptcy concerns in the rearview mirror. She intended to file a prompt motion to intervene. Yes! Right? She's a real ape, obviously. Allegheny's not. They wanted to take that awful settlement, guys. That showed their true colors right there. What we really need protection from is the reverse split and the ape to AMC conversion, right? Miss Izzo wants to protect us from that. Okay. This seemed procedurally appropriate. The court, following 67 pages of analysis, ordered the parties to confer on and submit a schedule for the remainder of the case, plaintiffs to file consolidated complaint. Thus, the opinion appeared to lift the scheduling order's provision prohibiting class members, pending final determination of whether the settlement should be approved, from commencing or pushing any action asserting claims in this matter. Yet at 11:07 p.m. on July 23, 2023, before the opinion's ink had dried, plaintiffs filed a letter, not a motion, with an amendment to the old settlement. The new settlement. Curiously, the new settlement's revised final order still names Munoz as a plaintiff and proposes that he receive an incentive award. Plaintiffs asked the court to approve the settlement on the revised terms and stay the opinion pending your honor's consideration of the amended stipulation. The new settlement letter not only inappropriately seeks substantive relief, it calls into question the finality of the opinion and consequently the effect of the scheduling order. Ms. Izzo does not wish to risk contravening this court's directives and therefore seeks clarification that the opinion is a final determination, which would allow for a motion to intervene to be filed. Alternatively, if the opinion is not final determination for purposes of scheduling order, Ms. Izzo respectfully moves to maintain the status quo order pending appeal of any final order approving any amended settlement. The new settlement leaves in place terms that Ms. Izzo contends violate the limitations on the release of future claims. Because of the opinion ruled on this issue, Ms. Izzo would appeal an order approving the new settlement, raising this argument and presumably others. Maintaining the status quo order would be necessary to ensure that Delaware Supreme Court can meaningfully review any revised settlement. Argument: the opinion is final, permitting intervention by other common stockholders. While the opinion did not reach every issue raised by the objectors or every exception to the special master's report, it fully disposes of the old settlement. The opinion instructs the parties to schedule the remainder of the case, which would presumably include the ability for other stockholders to intervene. This path differs from recent cases where the court, having otherwise approved a settlement's terms, explicitly invited revisions to an overbroad release. Ms. Izzo thus intended to file a motion to intervene. She could then litigate the case or settle for a more favorable result, potentially alongside other investors who, unlike plaintiffs, saved the company during the COVID-19 pandemic. Plaintiffs apparently continue to believe that their settlement is necessary to save the company from financial ruin. It makes little sense for defendants to continue litigating against opponents who concede that, even if they were to win a preliminary injunction, would not seek to make that injunction permanent. Permitting intervention is particularly appropriate because the recent amendments to Section 242 and AMC's required annual meeting render it unnecessary to continue the breakneck pace of this litigation. The thesis underlying defendants' entire scheme is that A, the apes mirrored voting is necessary to counter rational apathy among AMC stockholders, and B, AMC needs additional equity capital to stave off bankruptcy. The amendments in Section 242 change this analysis. Even assuming the company were to need additional equity capital to avoid disaster, Section 242 permits AMC to seek a share increase on a shares voted basis. Yet the parties have not explained why Section 242 does not permit company to renew its plans to issue new common shares in an amount that would not trigger the conversion. Were the sole purpose of a share increase to raise capital, this would make sense. As the price spike that followed the opinion suggests, the company would likely raise far more by selling additional common shares without first converting the apes. The company's next annual meeting, which one stockholder has sued to compel, provides a vehicle to do so if necessary. As the court recognized, the old statement had the practical effect of reallocating the ownership of AMC's equity between its common stockholders and the ape unit holders. So does any equity capital raise, which would likely involve dilution. The conversion, however, is a massive transfer of wealth from common to preferred that, if it were ever justified by rational apathy, is not today. Ms. Izzo seeks to intervene to benefit common stockholders, the unlikely heroes, rather than hedge funds like Antara that bought cheap to give defendants votes. Wow! Ms. Izzo, who is this? We've got some heroes in this play, guys. Mr. Brian Tuttle's one of them, and Miss Izzo is one of them. What's her first name? Rose? Wow. Amazing. The first step, however, is clarification that the opinion has dismissed the old settlement and Ms. Izzo may intervene. If all parties still desire to pursue a new settlement, they should file a motion. A proposed form of order clarifying the case procedural posture is attached. The court should maintain the status quo order pending appeal. The new settlement, like the old settlement, seeks to evade appellate review by consummating the conversion before the Delaware Supreme Court can hear an appeal. The new settlement would lift the status quo order immediately, even though the settlement's effective date does not occur until after appeals are exhausted. The intent is clear. The parties seek to make many types of post-appeal relief impossible before appellate review is possible. Ms. Izzo's objection notes many forms of post-appeal relief, including monetary damages, are available. However, if the status quo order is lifted and defendants complete the conversion, the 8 preferred units will disappear and the settlement consideration will be distributed. Even if an appeal succeeds, it would be difficult, if not impossible, to claw back the settlement payment, reinstate the apes, and restore class members to their pre-conversion status. This is amazing, beautiful, accurate stuff. Were the new settlement to be approved, Ms. Izzo intends to appeal and discuss below. That appeal holds a reasonable chances of success. She therefore respectfully asks the court to maintain the status quo order pursuant to the Court of Chancery Rule 62, pending appeal of any final order. Once a status quo order is in place, the party seeking modification bears the burden of showing why it should be modified. The court, in its discretion, may restore or grant an injunction during the pendency of an appeal. In consideration a motion for injunction or restoration of an injunction pending appeal, the court exercises its discretion under 4 Kirkpatrick factors. The likelihood of success on the merits of the appeal, whether plaintiffs would suffer irreparable harm if the injunction is not granted, whether defendants would suffer substantial harm if the injunction is granted, and whether the injunction would serve the public interest. At the top there where it says number 32, see at the top? The court could accomplish this in 2 ways. First, it could simply decline to lift the status quo order, allowing the parties to abandon the settlement if they choose to do so. Alternatively, it could lift the status quo order, which by its terms appeal applies until a ruling on the preliminary injunction motion that plaintiffs do not contemplate filing, and immediately grant the order attached here too. Okay, now at the bottom here it says each of Kirkpatrick factors favoring maintaining the status quo order. Guys, this is very important stuff. This could be huge for us. This is amazing, good, powerful stuff. We need Judge Zern to approve this. A, factor 1, an appeal raises fair ground for litigation. Kirkpatrick's likelihood of success on appeal factor cannot be interpreted literally or in a vacuum when analyzing a motion for stay pending appeal, as a literal reading would lead most probably to consistent denials of stay motions, because the trial court would be required first to confess error before it could issue a stay. Instead, the court considers whether the appeal raises a substantial question, that it is a fair ground for litigation and more deliberative investigation, and the other 3 factors strongly favor interim relief, then the court may exercise its discretion to grant a stay. Here, it is impossible to predict every issue that could be raised on appeal. The opinion, however, explicitly denied objections to the scope of the release relating to future claims. That holding provides a fair ground for litigation. Okay? As the opinion notes, the Supreme Court has made plain that the court's duty to protect absent stockholders carries particular significance when reviewing a release. The release may extinguish claims arising as of the end of the class period, which would not end until after the conversion, a date still in the future. Post-hearing events only exacerbate, I'm struggling to say that word, I apologize, the issue with the release. As noted, a stockholder has sued to compel AMC to hold an annual meeting. If AMC holds the meeting or even issues a proxy in advance of the end of the class period, that proxy may include facts in the complaints. A subsequent disclosure claim may relate to the ownership of common stock during the still pending class period, yet still be connected to facts in the complaints. It is at least a fair ground for litigation that the release of such claims contravenes Delaware law. Factor 2, AMC stockholders will suffer irreparable injury. Where the consequences of a ruling cannot be undone, a stay is more likely to be warranted. Here, the same facts that plaintiffs invoked to secure the status quo order support preserving it on appeal. If the conversion occurs, the resulting transaction will be impossible to unwind. Any post-appeal reversion to the status quo would be impossible. Not only would an undifferentiated class of common shares need to be somehow converted back to apes, but the shares created by the settlement itself would need to be dissolved. Yet those shares could have traded hands multiple times before the Delaware Supreme Court could rule. Factor 3, the parties will suffer no substantial harm. Meanwhile, neither plaintiffs nor defendants will suffer substantial harm by allowing Delaware Supreme Court to consider this case. Plaintiffs' counsel risk a delay in their fee awards. As for AMC, even Adam Aaron now downplays the concern. Absent the settlement, the risk materially increases of AMC conceivably running out of cash in 2024 or 2025. It says risk materially increases of AMC conceivably running out of cash in 24 or 25. Discovery in this case has shown that AMC has multiple short-term financing options, and as explained above, the amendments to Section 242 provide AMC with other means of raising equity capital. There is sufficient time for appellate review. Factor 4, the public interest favors appellate review. The public interest favors a stay pending appellate review. As discussed above, an appeal will raise at least one and likely several important questions which the Delaware Supreme Court should have the opportunity to consider. Plaintiffs and defendants should not be permitted to render much of their settlement a fiat accompli before this can happen. In summary, the Kirpat factors weigh in favor of maintaining the status quo order pending an appeal. Unless the status quo order is maintained, defendants can be expected to consummate the conversion, reverse split, and settlement payment before the Delaware Supreme Court can respond. Conclusion: for the reasons set forth above, the court should A. clarify that the opinion was a final determination, the scheduling order's litigation bar is terminated, and any revision to the settlement should be submitted via motion, and B. the status quo order should be maintained pending any appeal of any final order approving the new settlement. Wow. Margave Law, LLC, Anthony Rickey, Wilmington, Delaware. Wow, can we have him as our lawyer? Wow. Respectfully submitted, Theodore A. Catilia. Wow, so this is by Theodore A. Catilia. Theodore A. Catilia. Okay, that's a lawyer. James G. McMillan, lawyer. Okay, so these are public documents, okay? These are public documents. So I'm not exposing anything that's not public. These are public documents. Theodore Catilia certifies that copies of the foregoing Rose Isler's motion for clarification of the scheduling order, alternatively for maintaining of status quo order pending appeal, proposed order granting Rose Isler's motion for clarification, or alternatively for maintaining status quo order pending appeal, and this certificate of service were served on the following July 24, 2023 by file and serve express. Wow. Oh, look at this. What? Attorneys for AMC Entertainment Holdings, Inc. Adam Aaron, Denise Clark, Howard Koch, Kathleen Paulus, blah, 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 blah. And then it says at the bottom, Brian Tuttle, pro se. Wow. Brian Tuttle is in there. Wow. Okay, guys, I'm not a lawyer. This is not financial advice. I'm not a financial advisor. I did my best to read this to you. What do you think about all this? I think it's very impressive. Very impressive. And we need it. And we need clarification because we know the judge denied the settlement, right? But we didn't really have clarification. Like, is the reverse split and the ape to AMC conversion fully canceled now for good? You know, we didn't get clarification on that. And this legal documents giving us a request for clarification, and you know, we're going to see what happens, but this is a very good thing for us, and we need it to be approved, okay, by Judge Zern, and I think it should be, and I think it will be. So that's great news. What do you think about all this? Hit like, subscribe, and notifications. Share the video with a friend. Comment below, what do you think about all of this that I just read? Also, what do you think about the volume today on AMC? It's through the roof. High volume usually translates to a short squeeze. Adam Aaron was successful in crashing AMC stock today. That was his goal on Sunday night, and that's what he did Monday today. He crashed it. How? Fear, uncertainty, and doubt. And that's what his whole letter was. He said, we might run out of money. We need to do this now. We could run out of money. We might get bankruptcy. Look at Bed Bath & Beyond. Look at all these other companies that went under. He put out a lot of fear. And he didn't say a single word about AMC stock doubling on Friday from the court ruling. Not one word. Because he doesn't want it to go up. He wants it to go down. And his letter proved that. Right, friends? But this is great news for us. Thank you to Mr. Brian Tuttle for sending this to me. And if you were part of this, Mr. Tuttle, thank you for that as well. We are truly grateful to you and to the APE movement. Thank you to Miss Rose Izzo, okay, as well. And also whoever else is involved with this. Theodore Catalia, okay, the lawyer. Thank you to everybody, all right? Thank you to everybody that is part of this. And Miss Honorable Judge Zern, if you're watching this, please vote in favor of this. We need this. We need you to continue your fine fight for justice and continue to help protect the retail shareholders from the dark, evil forces of Adam Aaron and his hedge fund buddies. They're powerful, okay? They have a lot of money. They have a lot of dirty, dark things that they do to win. Continue to fight them, Judge Zern. Do the right thing. We are truly grateful, okay? Hit like, subscribe, and notifications. Talk to you soon. Have a great day.